A very good day to doctor and fellow friends. My name is Shobini, Doctor of Kobu, and my topic will be Suggestion to Improve Unfair Contract Terms Act Malaysia. In a global economy, the advancement in new technology and the liberalization of trade present challenges to the consumer protection regime of every jurisdiction. The survival of any regime of consumer protection law now depends on how it chatters for ways and means to correct the inequalities in the global market. Achieving a fair balance between the needs of market providers and the consumer is indeed a major challenge to lawmakers. The Malaysian Consumer Protection Act 1999 (CPA) was amended in 2010 by the Consumer Protection Amendment Act 2010, which inserted into the Part 3A entitled Unfair Contract Terms. The addition of Part 3A is a welcome move towards greater consumer protection in Malaysia. However, it contains many weaknesses, all of which could and should be addressed by enacting a single comprehensive piece of legislation on unfair contract terms rather than by simply amending an existing statute. It does not, for example, include unfair notices. Consumer can now worry less about whether he or she may claim under a defective contract. The same might not be said for a notice. For example, one notice excluding liability for negligence when using a swimming pool or car park, for example, is not covered by the new part on a plain reading of the bill, which clearly limits scope to standard form contract and does not mention notices. The inconsistency and the loopholes contained in the CPA should be reconsidered and remedied by the legislators and the courts. If the wording of the provisions are not adequate to provide remedies to the consumer, then the common law doctrine of inequality of bargaining power is more than enough to fill in the gaps. So let us look at the suggestion. First, Malaysia should enact a separate or specific piece of legislation on unfair contract term instead of adding it in the existing CPA. Besides that, Malaysia should set up an enforcement body that could take representative action on behalf of aggrieved consumer. This approach has been used in UK widely. A third, amending the Contract Act 1950 by adding provisions on standard form consumer contract. The problem with this alternative is the general nature of the 1950 Act. It does not have specific provision dealing with contents or the terms of a contract. Next, Malaysia can also adopt Republic of China model Contract Law of the People's Republic of China 1999. As a whole, it does not only focus on the contractual issues, but it also has provisions on consumer protection where principle of contract have been used as its foundation. Contract Law of the People's Republic of China 1999 contains 428 articles and 23 chapters, which covers the details of contract rules as to its formation, implementation, remedies, and many others. As regard to standard form contract, there are 4 articles which directly touches on this matter. Article 39 emphasizes on 2 important criteria of fairness and notification which must be fulfilled by those who prepare the standard terms of contract. Number 5. Our neighboring country Thailand has enacted the Unfair Contract Terms Act 1997 TUCTA to uphold the legal principle in relation to juristic act and those contracts which are based on the principle of Sacredness of declaration of intention, its main justification to combat unfairness in their society. Therefore, Malaysia can adopt this act in order to protect the contracting parties from any deviation from their two principles. Conclusion. In conclusion, such urgent reform of the current consumer protection regime against unfair terms in standard form contract is necessary to reduce the exploitation of consumer in Malaysia and to redress the imbalance in bargaining strength between consumer and business entities. Thank you for listening.